Last 5 minutes.
5 minutes, my Lord. 4 points in support of Proposition 2, less than a minute each, I think. My Lords, first I want to deal, if I may, in support of Proposition 2, the how we deal with it point, that there is nothing in the inter orem argument. In our respectful submission, the Strasbourg Court is absolutely right to think that there will be no disruption of our summary basis for dispatching possession claims in bulk by the admission of this proportionality concept. The inter orem argument would no doubt have been deployed in 1980, when for the first time this form of security of tenure, reasonableness, was extended to council tenants. But it was without any difficulty at all, and our courts find it possible to deal with tens of thousands of reasonableness cases each year without any difficulty at all, and indeed allotting a few minutes to each.
How do you deal with issues in a case like the present in a few minutes, where somebody, I mean, if you're contemplating they would be covered, somebody says, actually, the reviews, the facts are all wrong, and I want to challenge them?
May I deal with that, my Lord, in showing how we'll deal with it procedurally, if I may? Let me, if I may, before I answer my Lord Mance's point, just finish on the general aspect of the inter orem point. Another dimension of it is that it will raise all possession cases up to the security of tenure type threshold. That was the approach of Lord Justice Laws in Smart. What we say about that, with respect, is it does no such thing. The starting premise in the security of tenure case is that the tenant should ordinarily stay. That's security of tenure. The starting premise in this class of case is that the tenant should ordinarily go. Finally, on this point, we do not, with respect, share Mr. Stillett's submission that proportionality is limited to some form of fallback. That is, in our respectful submission, not a correct reading of McCann of the subsequent cases. As my Lady Hale pointed out, the central paragraph in McCann is paragraph 50. That has been carried forward in all the subsequent cases expressly, and it is that introduces the circumstances of the occupier as an important material factor in proportionality. But can I then come to my Lord Mance's question in dealing with my second of my 4 points, which is procedure? My Lords, we've included at tab E1 of the additional bundle the procedure by which the courts will manage the proportionality issue in the context of a possession claim. Behind tab 1, I'm afraid the pagination is at the bottom left-hand page, bottom left-hand corner of each page. If the court would kindly turn forward to page 3 of the photocopy, the court will there find Civil Procedure Rule 55.5, which at sub-rule 1 provides that on issue of a claim form, the court will fix a date for the hearing of the claim when it issues the claim form, and that is between 4 and 8 weeks after the date of issue. So there is an immediate date fixed for the hearing of the landlord's claim. What occurs at that hearing is specified by Rule 55.8 over the page, and that provides that at the hearing that has been fixed, or at any adjournment of it, the court may do one of two things: A, decide the claim, or B, give case management directions. It is sub-rule 2 that enables me to deal with my Lord Mance's point, because the rule provides that where the claim is genuinely disputed on grounds which appear to be substantial, case management directions will then be given. So there is an immediate filter which enables the summary dispatch of possession cases in most circumstances. It is that unless something is raised by way of dispute on a ground that appears to the judge to be substantial, then summary possession shall be granted. It is that sub-rule that enables district judges of the county court to deal with a dozen or so cases every 30 minutes. It is because they are able to sift the chaff from the wheat, and in the great majority of cases, make the orders they need to make. But there will be some cases in which, as my Lord Mance indicates, the proportionality question will appear to be substantial. My Lady Hale asked Mr. Drabble if there are examples of where this had been done and tried by the county court judges, and there are two. First, there is McCann itself, which was tried on a proportionality basis in the county court, and the judge's judgment is referred to in McCann. The judgment in McCann was reversed in the Court of Appeal because the judge had not followed Quasi in that he had engaged in a justification trial, which Quasi doesn't permit. On the same day, that the Court of Appeal reversed the judge in McCann, the Court of Appeal also reversed the judge in a case called Kibata, Kibata, which my lady will find at 2004 Housing Law Reports 28, and that was another proportionality consideration. Both of those, however, are in notice to quit cases. One a sole tenant's notice to quit, one a joint tenant's notice to quit. So, my lord, the way in which the procedure will operate is that will provide the filter, Rule 55.8.2. Our third proposition is that, with respect, we invite the court to reject Mr. Stilitz's suggestion or submission that this court should devise some sort of checklist. We respectfully suggest that a checklist of factors on proportionality will not assist. The highest court, the House of Lords, never needed, in all the years of the Rent Acts and the Housing Acts, to offer a checklist on what reasonableness covered. It trusted the judges. I respectfully ask this court to do the same, and to follow, therefore, the approach that Lords Bingham, Walker and Nichols took in Kay, and that is to leave it to the good sense of the judges to identify whether the claim for possession is disputed on grounds which appear to be substantial, i.e. whether there's anything in the proportionality point. We resist the checklist, not least because personal circumstances are a consideration on proportionality, and there is, as the court will appreciate, a huge range of human factors and circumstances. It is not, in our respectful submission, sensible to seek to prescribe a checklist. We would urge the court not to substitute for the simple question posed by the article, would it be proportionate to evict, some other test, such as is it exceptional, highly exceptional, is it a case of exceptional hardship? The judges are as able to deal with proportionality as they are with reasonableness. Finally,
does the court have to assess too how powerful, how overwhelming, how important is the local authority's case?
My lord, it will take into account what is the legitimate aim being pursued. That is the whole part of the exercise of ascertaining whether it's necessary.
So it'll just have to review how much good will be done by getting possession in one of these cases.
Yes, my lord. And moreover, the court will be in a good position to know what the authority's case is if it follows the process envisaged by the procedural rules of the practice direction of filing a witness statement setting out why it's going for possession in this case. That will put the defendant and the court on notice. That is exactly what Lord Justice Waller envisaged in McClellan at paragraph 103, and what Lord Bingham envisaged in Kay.
How long a hearing to envisage?
I beg your pardon, my
How
lord.
long a hearing to envisage in the County Court for one of these cases?
My lord, it will take less than 5 minutes for the judge to determine whether the case is genuinely disputed on grounds which appear to be substantial. If it does so appear to the judge, he will give directions for a trial.
And how long will the trial take?
Perhaps half a day, my lord. About as long as the court would give to a small claim dispute about a dry cleaning malfunction or the breakdown of a washing machine. In our respectful submission, this class of case deserves much greater attention than that.
Including this very case?
I beg your pardon, my lord.
Including Mr. Pinnock's case?
May I respectfully decline to offer the Commission's opinion on this particular case, my lord? That's a matter, I think, for Mr. Drabble. My lords, may I finish by indicating that we identify, despite our approach, certain difficulties in accommodating the Strasbourg Court's analysis. The first is, how do you deal with factual disputes, where the occupier says, I didn't do it, or I wasn't there, or is a mistaken identity point? In our respectful submission, the Court's procedures have to yield to accommodating and resolving those disputes of fact. I remind the Court that the House of Lords remitted to the High Court in Doherty the determination of that proportionality issue on the basis of the resolution of disputed facts. So the trial judge is sometimes going to have to deal with that. The last of the Irish cases, Pullen, at tab E7, deals with that point at pages 44 and 45. There is another practical problem, which is the one my Lord Newberger drew attention to yesterday, and that is the potential here for the creation of more tolerated trespassers, because you may reject the claimant's claim for possession, but nevertheless uphold as lawful the claimant's earlier decision to give a notice or notice to quit to determine the tenancy. But in our respectful submission, even that can be dealt with by declaring the notice to quit bad where it was bad, or leaving the person in occupation with no rights. it's never been the submission of the Commission that Article 8 creates positive rights to occupy land. The best the person is entitled to is to remain in occupation under whatever right they do have until lawfully ousted by the claimant in the court. Our third proposition that we've put in typing is that Section 6.2b will rarely, if ever, be of relevance in housing possession claims. I'm not going to develop that, not least because I have no time, but because it's been well covered by Mr. Stillitz and Mr. Drabble, whose submissions we adopt. But the Commission is anxious that I emphasise the point that Mr. Stillitz made, that what the House of Lords had to say in Doherty about Section 6.2b is deeply troubling in its wider application to issues well beyond housing in the interpretation of the Human Rights Act. It is unfortunate the way in which the matter was dealt with in Doherty. We invite the court to say that on proper analysis, Section 6.2b has no role in this class of case.
That criticism, I think, to be fair, is really directed at me quite properly, isn't it? I mean, Lord Walker's analysis, would you endorse?
Yes, my Lord. My Lord will recall, and Mr. Stillitz touched on this, that the account is set out in Lord Mance's speech as to what happened in Doherty. It all went off in the wrong way.
Right.
The point wasn't correctly argued. I was appearing in that case for the occupier, and it was in rather peculiar circumstances that I invited Mr. Sales to seek leave to address the House in reply to the points that have been, as it were, rather surprisingly advanced in that case. Unfortunately, it is my respectful submission that the House was led into error in relation to 6.2b in that case, and that the analysis of Lord Walker and Lord Mance is correct. My Lord, I intended no criticism whatsoever of your Lordship, and I'm sorry I came across in that way.
I'm not taking anything amiss at all. I was just trying to understand what you were saying, because there are certain bits in Doherty, looking at it now, are quite useful, I would have thought.
My Lord, I can't really develop it further without going over ground that's already been identified. My Lord, I've done that at a gallop in order to keep within my time restraint, but I must offer the opportunity to your Lordship to put to me any questions that would be of assistance.
No, thank you very much, Mr. President.
Lords, Lady, we recognise we put in an extremely lengthy case. I apologise for that, but I thought it was necessary for a number of reasons, principally because we, unlike the interveners, do have to address the specifics of the case so far as they are challenged, and unlike the appellant, we do not think the broader issues can be pursued on anything other than a detailed basis. It's also right that I'm the only one with three opponents, well, possibly I should say at least three opponents. We were and are therefore concerned about how much time would actually be available for two justices to each of the 12 issues, two of them subdivided into 9 sub-issues, especially when addressed before we even get to our feet by 3 advocates. At risk of imposing on you, we've therefore resorted to what we recognise are, in effect, written submissions, which in relation to some of the issues we're going to rely on wholly, but at present we're not abandoning any of them. Whether we do so in the course of it remains to be seen. Lords and Lady, we propose to make our submissions under headings we've handed in a sheet,
Yes.
which hopefully you have. It was just to try and, we found it a little difficult to reconcile all the issues, the grounds and so on, and to bring the issues together, because there is quite a lot of circularity in some of the issues. And so we've tried to bring our submissions into some degree of framework. But we're going to start, where we'd like to start is with the European cases, which in a sense is what has brought us all, well, as I said back here, but actually all here. The forum has changed. I appreciate you've spent quite a lot of time with them, in particular as to the jurisdiction dispute between Mr. Drabble and Mr. Luber on one hand, and Mr. Stilitz's rather narrower long-stop jurisdiction. But all of that has tended to accept the proposition that Strasbourg has said that a proportionality jurisdiction determination, independent determination of proportionality, is necessary in every case. So the emphasis has been on what the jurisdiction comprises. We may foster...
In every case where the issue is raised.
All right, in every case where the issue is raised, sure. Yes, Lord. We may have fostered a degree of complacency in this, at least a little bit, because in our printed case we did tend towards accepting that there was an emerging line of thought that such a jurisdiction is invariably required, although we never went so far as saying so, and we clearly rejected and still reject the notion that it was constant or clear. Indeed, we've emphasised how recent it is, and we've clearly queried and doubted whether it is what the cases would properly be held to mean, e.g. at the Grand Chamber. So come back to that. But mostly prompted by the Commission's printed case and the very wide description that Mr. Luber offers of the sort of cases which he contends are all within such a jurisdiction, we went back to the key cases to see just how true that is, or at any rate, how clearly or how constantly it has been asserted. Put another way, with three counsel marching so far as this goes in the same or a similar direction, it seemed to us we perhaps ought to review this underlying assumption, rather than let it be taken too much for granted. So I hope you'll bear with me if we go back to them with that specific question in mind, whether there has been a clear and constant line which says what all the others here assert about there needing to be a proportionality jurisdiction in every case. We do so bearing 4 points in mind. First, that Strasbourg has over a long period stated and restated that the Convention is about a search for a balance between the interests involved. And if we want a recent source for that that's in the bundle, there is, I'm not suggesting we go to it, if I can just give it to your lordships, your ladyship. Stankova, bundle 13, tab 117, 58 to 59. Secondly, that the states have a considerable margin of appreciation, particularly in socio-economic areas such as housing, a proposition originally derived from or stated, at least so far as I recollect, in James, which was an Article 1 case, but Bleckich has said, and I think we've seen the passage actually, and I'll remind you of it when I come to Bleckich briefly, has said applies to Article 8. Thirdly, that there has been a number of cases, the older cases, where Strasbourg has not scented any breach, notwithstanding the absence of any such jurisdiction. Of course, we understand that concepts change with time. That doesn't make everything in the past irrelevant. And fourth, that the Strasbourg approach to cases is different to our own common law approach. Mr. Stillitz touched on this. Common law has been a process of argument from the particular to the general principle, not the application of a general principle to the particular. That is to say, cases were determined according to their facts, generating a proposition, the ratio, that then served to apply in other cases. In Europe, the tradition has been one of identifying the principle and applying it to individual cases. Now, I accept and recognise that Europe is moving towards something more of an approach of laying down rules that can be applied across the board, but it is at best emerging from, and probably still is, a case-based approach. And if I can just mention Zahentner at 60 for a statement of that within the cases that we've got. That exercise does produce rules which are somewhat less rigid than the way precedent works, in generating rules.
Can I ask you this, Mr. Arden? In terms of actual practical result, what you're taking issue with, does it make any difference? I mean, possession proceedings started. The tenant raises Article 8. The court looks at it and, taking Mr. Luber's point, after 5 minutes or less, says there's nothing in this or it's a good point. If nothing in it, possession order made. If there's something in it, then maybe it goes off to a hearing, either the administrative court or in the county court, depends. How does your process differ?
I haven't got to our process.
No, but how would it differ, just to see where we're going to in terms of...
Where we're going to is we say this scheme is compatible.
Without having to look at that at all?
Yes.
In any case?
In any certain cases. That is what I'm developing here, Lord.
In any what cases?
In any of certain cases. I'm saying there is no rule, or I'm submitting that there is no rule that there is invariably a requirement for a proportionality hearing in every eviction.
I understand that, but my concern is that I'm not quite sure how it differs, because if in some cases it is and in some cases it isn't, in each case the court's simply going to have to look to see whether it is such a case.
No, I understand what you're saying. I'm saying that there can be categories of case where it's not required.
I see.
But are you accepting that Article 8.1 will always be in point in these cases? Because you only get to Article 2 through 8.1. I mean, presumably...
Well, I think your Lordship said that Article 8.1 is applicable.
Yes.
I think we've gone beyond that. Yes,
right,
it is.
So you do accept that at least?
Yes,
so
I'm not trying to go back beyond that.
No, so we have that starting point in all these cases.
But I am saying that if you read the cases as we read the cases, Strasbourg does recognise that it may be that some cases do not require. That is our submission.
Okay. Can you give us
Well, we will say
the
certainly...
categories?
I'm so sorry.
The categories, yes.
We would certainly say the categories we're dealing with here, which we'd identify as introductory and demoted, and probably some others.
So in the case, no demoted, that's what I was really getting at. So it would be a very different process, because any demoted tenancy case would be a category of case where Article 8 wasn't...
We say, yes.
Article
We
8
say
wasn't...
we would say that the legislation which deprives the occupier is justified, and that Strasbourg has left that door open.
Okay, thank you very much.
That's our point.
Yes, I was just seeing where it was going to. I'm very grateful, thank you.
Our submission is this, that the cases do not show clear and constant jurisprudence that every eviction from everything that qualifies as a home, however fully so or however provisionally, however long-standing or short-lived, whatever the circumstances, must be attended by an independent determination. Proportionality, only that there has been a number of recent cases, and we shall see with them, from what clearly were full and long-standing homes, where there was a breach for want of such a determination. That is our point. And I can deal with this very briefly, because your Ladyship have been to the cases, and I'm only going to alight fairly briefly on them. But Lord, we started with, and they haven't really been approached from this perspective, we do want to start with Connors, which was Bundle 12, Tab 105. And I confess, the way I read paragraph 94 may be different from the way, certainly at one point, the spoke to my lady to be reading it. And it's at paragraph 94, that's all I'm going to go to. Your Lordship's Ladyship are very familiar with it by now. And it is that second sentence. No, I'm sorry, the first and second. Even allowing for the margin of appreciation which is to be afforded, the court is not persuaded that the necessity for a statutory scheme which permitted the summary eviction of the applicant's firm has been sufficiently demonstrated. The power to evict without the burden of giving reasons has not been convincingly shown to respond to any specific goal or provide any specific benefit to members of the gypsy community. Now, in our submission, those two sentences suggest that it is possible that it could be done. We would, of course, rely on the overarching purposes and the benefits to the social housing in the area. So our first case and is our submission is that plainly envisages it was not, as a matter of theory, absolutely ruled out. We go on to Bleckich, which is 102, sorry, same bundle, 102. I wanted to pick it up. It's a little more tentative and a little less clear-cut on this point, but I think it does go into this pot. Paragraph 59, page 195, in determining whether the impugned measure was necessary, the court had to consider whether, in light of the case as a whole, the reasons were relevant and sufficient. Notion of necessity implies pressing social need must be proportionate. In addition, the scope of the margin of appreciation enjoyed by the national authorities will depend not only on the nature of the aim of the restriction, but also on the nature of the right. If we emphasise those last words, we recognise they're elaborated in the next paragraph. In the instant case, satisfying housing needs must be balanced against the applicant's right to respect for her home, a right which is pertinent to her own personal security. The importance of such a right to the individual must be taken into account. Could be said that what the court therefore means by the nature of the right is home within Article 8, meaning all cases involving the loss of a home. That may be a somewhat rigid reading. It remains the importance of such a right to the individual, and it can be said, and is undoubtedly the case, that there are significant differences in the importance to an individual between the loss of, say, a wholly secure tenancy and a tenancy of a house one has occupied, or a tenancy of a house one has occupied for a very long time, and the loss of what is a temporary home. For example, under homeless persons exceptions, I think your lordships, your ladyship, I think many of you are aware that there is an exemption from security for those we are housing under the homelessness powers, pending finding them, as it were, a final home. It's paragraph 4, schedule 1. Or indeed, the loss of what is not yet a fully secure home. I'm probably saying no more pithily than borrowing from Lord Staines's famous dictum, context is everything. But going on to 64, if I may, the court accepts that where state authorities reconcile the competing interests of different groups in society, they must inevitably draw a line marking where a particular interest prevails and another one yields, without knowing precisely its ideal location. Making a reasonable assessment as to where the line is most properly drawn, especially if that assessment involves balancing conflicting interests and allocating scarce resources on this basis, falls within the state's margin of appreciation. It does seem to be envisaging there could be cases where a line is drawn without needing to go into the specifics of every case. 65 is the paragraph to which I referred earlier, and this is all I seek to get from it, which is to say that the proposition about the breadth of the margin of appreciation does apply in Article 8 as well as in Article 1 of the first protocol. Connors at 82 appeared to be drawing a distinction. And the margin, at the end of 66, the margin is afforded both to the domestic legislature and to the bodies that are called on to interpret it. And I think that partly supports Mr. Stillett's response to your lordship's inquiries about how relevant the domestic legislation would be if you were just carrying out a proportionality analysis. And 68, of course, what it says, the court must therefore determine whether, having regard to the circumstances of the case, notably the importance of the decisions to be taken, the applicant has been involved in the decision-making process seen as a whole to a degree sufficient to provide her with the requisite protection of her interests. And obviously we say that nothing in that equiparates to a requirement for an independent determination of proportionality in every case. And in the two cases with which I'm most concerned, because in our submission you can't distinguish between them, remoted tenancies and introductory tenancies, there is the review process and there is a considerable involvement in the decision-making process by way of review. Lord Milady, going next to McCann, fortunately, in the same volume at the very back, tab 111, paragraph 50. I'll be very brief here. I'm simply referring to the fact that they say any person at risk of an interference should in principle be able to have the proportionality determined by an independent tribunal. And those are the words we emphasise. We accept that one way of reading that is to translate it into a rule in the ratio sense as meaning as a matter of principle in every case.
I think the tradition of the court is rather different, actually. Though when it says in principle, we've seen it in other cases, it does tend to suggest that there may be exceptional circumstances, but one finds it actually sometimes put back to back. You have the principle stated and then the exceptional is stated. Do we get the exception written in here? Or?
No.
We don't. So that's it a little bit.
Save that. The next sentence is the court notes that the legislature has a complex system, the allocation of public housing, about which the applicant does not complain. Now, I don't know if that was a reference just to Part 6. I didn't read it as that, I must admit. I rather read it as meaning the whole structure, which of course includes exceptions. So that was, and it doesn't express any disapproval of it. Lord, yes, I was going on to say, yes, in principle it's an entitlement, but there may be exceptions. Maybe cases where it can be overtaken by other considerations. Given Connors and what we say about paragraph 94, we would say the latter reading is the correct one to give rise to some kind of consistency. It's also the only interpretation that accounts for earlier cases like S, O'Rourke, De Palma, and possibly Ure, in the sense that in the first three of those, what can be seen to be decisive is that there were statutory provisions which dictated the outcome, which included no independent determination of proportionality. While in the fourth, the argument which was later to be put in McCann, a secure tenant losing his home because of the operation of the common law, was not very thoroughly developed, with no disrespect to the court.
What were the four? X, De Palma, Ure? You said there was...
S. O'Rourke, De Palma, Ure. O'Rourke. Bundle 13, tab 113.
Thank you.
I mean, your lordships were taken to Ure, and may recall that it says, well, at the outset it was clear that if one of the joint tenants left, the other would have to do so. I mean, that was clearly very superficial, because it was quite wrong, because one joint tenant can remain in occupation, and the secure tenancy is maintained as so long as one of the joint tenants is using property as an only or principal home. I'm going to come back to the question of joint tenants in a minute, but if I can finish. Of course we accept, again, there were some changing attitudes like in P and in Ure. We get in Kosich, since the volume's open, I'll just, it's tab 107, 21 to 22. I think your lordship, your ladyship have already got it marked. I do think that the way it's put there, and I accept that, the way it is put there certainly does appear to be the wider statement of principle, getting very close to, or maybe saying, in every case. In other words, where it says regard being had to particular circumstance of the case without any qualification. And of course, we also have the advance from proportionality into reasonableness, which does rather, at least domestically, complicate the matter. But it's Zehentner I want to go to next, which is at bundle 13, tab 122. And at this stage, I'm not really going to it. I mean, I will take up the points I make, or the passages on application in the private sector, but really my purpose for going here is to do with whether it is indeed an every case jurisdiction. I think you've had the facts, Lord and Lady, Mr. Drabble showed you. At 35, we get clear that the principal complaint was under Article 8. 58 it might be thought the expression at the beginning of 58, the procedural safeguards available to the individual be especially material, might hint at them not being definitive. And then it cites Connors and McCann. At 60, I mentioned this in my first few observations, the court recalls in proceedings originating in individual application. It has to confine itself so far as possible to an examination of the concrete case. I then want to go to 65. In the present case, neither the protection of the bona fide purchaser, and this wasn't the individual one being weighed up, this was the argument, the government's argument, nor the general interest of preserving legal certainty are sufficient to outweigh the consideration that the applicant who lacked legal capacity was dispossessed of her home without being able to participate effectively in having proportionality. Now, we say that is not the language of the absolute rule. Incidentally, it does clearly apply to a private relationship. Although both Mr. Drabble and Mr. Stillitz still rely on time. But that's not the issue I'm dealing with now, and I'd like, therefore, to say, oh, I'm so sorry, I still wanted to go to Paulich, tab 113, tab 115.
Sorry to hold you back. Just looking at it just strikes me at 65 reads more like the working out of the principle of proportionality than an exception to it. And I wonder whether the first sentence of 55 is...
It was addressed to the arguments. It wasn't being addressed to the particular bona fide purchaser.
No.
The argument was that you needed it for the protection of the bona fide purchaser as a concept. Paulich is at tab 115. It's the last of these cases, so pick it up at 42. Actually, I'm not entirely sure that you haven't got it, you really need to go to it. I was going to say was that 42, the whole of 42 is in fact a direct expression used was boilerplate from Kasich.
Well, in fact, Paulich was given a week after Zahentner. 4 members of the court was the same, including the president, and I think the the registrar was the same. I mean, unlikely to demonstrate an inconsistent approach. And it may be that Paulich was very much in line with the others, and with I think President Rozakis was the president of the court in almost all the cases, except I think for Connors. I just wonder whether that rather underlines the point that Zahentner is a very different case, and that the origin of the claim for possession, the right to possession, originated from a court order, not from a contractual right, whereas in all these other cases, it originates from a contractual arrangement.
Can I take two points?
Please.
Well, first of all, McCann, I think, was 4th section, but the remaining cases, and Connors, but Zahentner, Paulich and Kasich, and indeed the recent Russian case, are all 1st section, so you do get a considerable overlap.
Exactly.
The second point I'm making about Zahentner, while I understand it's coming from the court order, I may be forgiven, Lord, where I see that your Lordship is making a particular point in relation to whether and how it applies in the private sector, to it horizontally.
No, it's because the court is exercising its jurisdiction from the beginning. The right to a claim for possession originates from a court order in Zahentner. All it was a debt.
Yes,
it was converted into a right to possession because of the court order. At some point in Zahentner, the court says you've got to look at the court action as a whole. The charging order, as we would call it, was made at a time when Miss Zahentner was not really capable to represent herself, and therefore one's seeing it as a whole, and it's a very different case, I suggest.
It may well be, my lord, and indeed is, and I accept that, and I don't think I did advance the private sector point wholly in terrorem.
Well, it's not so much the private sector point, it's the court being involved in the thing under legislation, rather than simply giving effect to what would otherwise be a right to possession.
Yeah, but 65 still seems to envisage that there could be legislation allowing them to do that if it was justified without a proportionality hearing. That's my sole point.
I see.
It's a very narrow point, Lord, I accept that. But it does seem to be envisaging that it may be possible to outweigh it. In that case, of course, you would have a challenge to the legislation. I'm sorry, in this case, there could be a challenge to the legislation. Well, there hasn't been one. And we are saying that these cases do not amount to the proposition. We think it's become somewhat syllogistic. This is a home gets an independent determination of proportionality, this gets an independent determination of proportionality. In the context of what we're told is a constant search for balance, affording a margin of appreciation, we submit that's a rather crude analysis, much less sophisticated, either than the issues called for or than the Convention is entitled to. Bearing in mind that the demoted tenancy is directly modelled on, it's sort of son of introductory tenancy, as Mr. Stillitz explained and took your ladyship to the evidence, and bearing in mind, of course, that what the procedure does is to wholly end the secure tenancy. It's not a change of status, statutory status alone. The tenancy itself ends, and there is then a new tenancy, in effect, back in the position of an introductory tenant. I want to use the introductory tenancy to make this point because it's more straightforward. There is in our submission something very surprising. My note says absurd, and I chickened out the point of saying it, but very surprising to absurd about saying this. We make a provisional offer of a home to someone on the basis that it will only become a home if we decide that he has behaved himself as a tenant for a year. It can today be extended to 18 months, but it's not really relevant. There has to be a review and so on, even of that. To say that it's a breach of his human rights if he does not enjoy an independent determination of whether or not we have to follow through on that full allocation. Even though, which is trite, we have no obligation under the Convention to offer a home or indeed to offer any particular security. Well, this is the point we're making about an introductory tenant. That and we tried to make this in our printed case, that it is a provisional allocation which is completed on our decision in our decision not to evict. It becomes a full home at that point. And we do not understand how Europe can say by implication, and that's how it has to work, that such a way of offering accommodation is itself incompatible, even though there's no obligation to offer accommodation. Of course, we make the same point about a judge on a fully compliant basis having decided to take the secure tenancy away, replacing it with a new introductory tenancy. We might say there is a third sort now called a family intervention tenancy. I'm not going to go there, but it doesn't work quite the same way. But it's addressed to the same very major problem, very significant problem of antisocial behaviour. And we also say the same, that it's highly surprising, we would say, borderline absurd, an equally easy example of a homeless person's tenancy excluded from security under Schedule 1, Paragraph 4. We have decided, we the authority that is, beyond the requirements of the Convention, that we will find someone a home. It's taking time because social housing is an extremely scarce resource. Until we can find you somewhere, we have an obligation to, and we will house you under what is essentially a temporary arrangement. We all know it can take months or years, we accept that. When we've found somewhere, so we want you to move on to it, you have lots of reviews and so on of that offer, it's nonetheless up to a judge to decide whether or not we can complete the task we are engaged in. It's, in one sense, voluntary task, because the Convention doesn't force it on us, or whether you can simply decide to stay where you are mid-process. The same sort of propositions we say apply if we offer someone a temporary home for 1 year in order to allow someone to take up an offer of accommodation. It was part of the job mobility policies, in order to find somewhere for themselves, or likewise to attend a student course till the end of that course. These are tasks we don't have to do, tasks where there is an evident policy, there's an evident propriety about it. In our submission, Strasbourg does not require this. None of the cases I'm referring to here or any of the Strasbourg cases come anywhere close to the sort of case I'm talking about here. None of them do at all. Margin of appreciation left to contracting states depends on the nature of the right. Context is everything, and that is certainly true of the Convention, the search for a balance. And in our submission, this needs to be borne in mind when considering the recent European dicta on the right to an independent determination, because the loss is an extreme form of interference. Yes, but how extreme it is certainly relative to what that right is to begin with.
Mr. Rodden, I mean, just take an introductory tenancy and say, after 11 months, there it is, the authority, for their own reasons, they have somebody they're particularly keen to house, they say to this introductory tenant, you've no security, out you go. And just assume that he happens to be in one of what Mr. Sillett, I mean, rightly or wrongly categorises as valuably as an exceptional case, but assume, take 1-2, he's terminally ill near the end of his life, although he could safely be moved, he wants to live out his remaining days there. Now, I mean, are you saying that if we, I mean, no doubt you would accept that there might very well be a Wednesbury challenge available?
Absolutely.
Yes, but just assume in a country, in a member state, Council of Europe state, that there wasn't any provision for rationality challenges or something like that, and it goes to Strasbourg. I mean, are you saying that Strasbourg wouldn't say there's a proportionality test that has to be satisfied here?
Lord, yes, because he has not yet acquired a full home which merits a proportionality challenge.
You are equating home with the quality of the legal right to remain, but Strasbourg has never done that.
I accept that, Lord. I did that once and didn't win a single bit of support in Kazi. I'm not going back to that. I'm not. I'm looking at the policy. I'm looking at the purpose. I'm looking at the quality of what has been offered as a home. It has not been offered as a permanent home. It's been offered as a home. We can have an interesting argument, and there is an argument to be had about in what circumstances you can determine, whether you can determine an introductory tenancy for the reasons given by my Lord Brown. But I'm for the moment, as I assumed your Lordship wanted me to do, taking on board that you could do so. Lord, yes, we are saying that there can be classes of cases where there does not have to be an independent determination. The Lordship's example is a very extreme one.
I dare say, but you agree there has to be an independent view as to whether that's reasonable. Well, why not equally an independent view as to whether it's proportionate? It's actually much the same question.
Lord, 2 points on that. First of all, it's judicially reviewable. My learned friend actually now accepts that that is sufficient to satisfy Article 6. I know he doesn't accept it's sufficient to satisfy Article 8. It's a rather surprising gap.
Well, it may well be that it would be regarded as, in most cases, it would be sufficient to satisfy Article 8. If it survives the rationality challenge, it might very well be thought at the same time likely to survive the proportionality challenge.
The decision to evict has to be lawful. Lord, what we're simply saying is, what is in issue here is not that individual extreme case, is whether there is a case for legislation which does exclude. We're saying that Strasbourg does allow, in those passages I quoted, that Strasbourg does envisage that there may be categories of case where an absence of a proportionality challenge is justifiable. That is our point, Lord.
What is proportionate? The argument, I mean, you're either arguing that this isn't a home at all, it's a flawed home. That argument seems very difficult to run, and I think you just said that you tried it in quasi and didn't.
I wasn't running it on the legal basis.
Yes, you're not pursuing it. Right, so we're within Article 8, and the basic, 2, Article 8.2, and the basic premise is then that we have to discuss proportionality. So your argument has to be that there are some situations where the scheme automatically strikes the proportionality balance, and nothing more is
I am
required.
saying that within the state's margin of appreciation, or here Parliament's right to respect for its democratic decisions, the Strasbourg jurisprudence does not yet say that there can be no schemes which do not allow for. That is what we're saying. But those passages which I quoted support that proposition, that there may be some schemes which are justifiable.
But what it really involves saying is that every introductory tenancy case, the Article 8.2 exercise will inevitably be determined, whatever the facts, in favour of the landlord, in favour of an order for possession, is the other way of putting it.
Yeah,
that's what it effectively amounts to. But I can see the argument in introductory tenancies that says the tenant is, I've got to be careful about compartmentalising it, but going to have a very, very, very high hill to climb to show on the fact that he's got an Article 8 argument, Article 8.2 argument. But isn't it rather contrary to the in principle view that you are saying in no introductory tenancy case, whatever the fact, can the tenant even have an arguable possibility, rather than saying it'll be a doubly exceptional case?
Yeah. If your lordship reads the cases as saying that in principle everyone must have it, then of course I'm wrong. I am simply submitting that it has not gone that far.
I see.
It's as simple as that. If your lordship rejects that, your lordship reject that premise, of course I've got nothing to say.
But one can imagine facts where a tenant who's had an introductory tenancy would have, on particular assumed facts such as those put forward by my Lord Brown, a stronger Article 8.2 case than a tenant who was an ordinary secure tenant.
One of our difficulties is that we've never been able to see any difference between proportionality, substantive proportionality, or wanted proportionality, and Wednesbury unreasonableness in the housing context. We have simply not been able to see it. And Mr. Luber produces cases where the Court of Appeal found Wednesbury or found domestic public law grounds, which in a sense supports this.
But isn't that rather a submission you don't want to make? Because if it's right, then Article 8.2 would apply in a case such as that put forward by my Lord.
This entire hearing on this main issue is about who reaches the proportionality decision. We are completely unworried about reaching Article 8.2 compliant decisions ourselves, leaving aside the procedural issue of demoted tenancies for the moment. We're completely untroubled by it. Most authorities do now explicitly address Article 8 in any eviction matter. In our respectful submission, most authorities have been applying Article 8.2 for many years. They do not make disproportionate, unreasonable decisions, and when they do, domestic law catches them out.
When you say the question is who, is this the argument about whether it should be the administrative court or the county court?
No, that's the forum issue. It's the method of challenge.
I see.
Thus, we have no problem with Lord Staines's approach in Daly. We have no problem with an intense, anxious review. We simply say at the end of the day in these cases it is our decision and the court can only review it on a secondary basis, not take it for itself. And that...
Is that the difference between you?
Yeah, that's what's this. I'll probably have to eat these words, but it's 90% of what this case is about.
But just a little footnote point. Do you say that the court can look at the facts as they are at the date of the hearing, or do they have to look at it at the date you made the decision?
It's not the court. The authority has to have a continuing decision.
It is the continuing decision. So the court will... Yes, that's what I assumed.
In our case.
So the court assesses the reasonableness of your decision.
Yeah.
So it applies a hyper-Wednesbury approach to your decision on the facts at the date of the hearing.
Possibly, but
possibly. Is that your submission?
When I say your lordship says hyper-Wednesbury, I don't really mind what it
the
means.
intense, Lord Staines's intense.
Intense
focus,
sure.
whatever you call it, yes.
But why not full proportionality review? You asserted that the local authorities have no problem about applying Article 8.2 and have done so for many years. And why shouldn't the court review their decision on the same basis? Why? And also, especially so, when you say the bases are the same.
Because, no, I'm not quite saying that, I'm afraid. Because, my lord, there can be more than one proportionate conclusion, just as there could be more than one reasonable conclusion. The issue is our right, the local authority's right, to take its decision within its policies. because its reasons and its policies are central to its proportionate decision. It's not for the court to take it, in our submission, according to the court's criteria and the court's policies.
I mean, you envisage a case, therefore, where the court would say, well, I personally, if I was judging this afresh, I wouldn't think this was proportionate, but I accept that it's rational for the authority to regard it as proportionate, and therefore I won't strike down this claim.
Yes, absolutely. And it is a standard thing that has been found in domestic judicial review for many years.
Is it within the range?
I'm sorry?
Is it within the range?
Within the range, yeah.
Not is it what I would do, but is it within the range of what an authority, bearing in mind its human rights obligations and Section 6.1 of the Human Rights Act, could do?
Yes. Now, this doesn't address the Section 6.2b, the procedural element, of course, at all.
And it doesn't much address Section 6.1 either.
Well, in our submission it does, because we are acting proportionately. Lord Stayne said that in Daly, as Lord Slynn said in Alconbury, it does not require the court to step into the shoes of the decision maker. It is a review. So, I mean, your Lordship's relationship have our first submission anyway, which is that there is not an obligation in every case to have an independent determination of proportionality. Lord Milady, of course, cases are decided within parameters. In our submission, we're not addressing here every single case. This, I think, is now beginning to give a more detailed answer, my Lord Newberger's original question on this.
So just on the matter we've been discussing, I mean, I'm just going back to McCann, paragraph 53. McCann is, of course, 12.111, paragraph 53, because this deals with judicial review. I mean, you're really asking for what they don't seem to accept there, aren't you?
Well, they don't accept it in McCann, where they had choices to follow a statutory scheme and to not, and chose not to do so. There is an interpretation of McCann that does not go as far as it's subsequently been taken, as indeed was submitted in the post-McCann submissions in Doherty. And Lord Milady, either there is some force in what I'm saying about paragraph 94 of Connors and paragraph 68 of Zahender, in which case the rule is less universal than it has been taken to be. Or in a sense, there's not. I'm wrong. It's simple. It's not a point that's going to get much stronger by repeating it. But in our submission, given concepts like margin of appreciation, given concepts like balance, it is really not that much of a stretch. It's no stretch at all, we would say, if we are right that it isn't required in every case, to say no, introductory tenancies do not get that. We are entitled to withhold that from introductory tenancies until. And likewise, we're entitled to withhold it from homeless persons within Schedule 1, Paragraph 4.
And the situation in K?
Well, this is precisely what I was coming to. I said this was prompted to. This is maybe long, but it is an answer, I think, to your Lordship's question. I said I was prompted by the Commission's printed case setting out 6 categories of types of occupation, which was set out. Can I answer it in my own way, as it were, my Lord, and come to, and it includes...
Yeah, because I mean, we'll need your comment on the question that the court has posed in K, won't we? Was it a good question or a bad question?
I'm sorry, my Lord, now I've managed to get lost. It's probably my own...
My Lord is referring to the question which the Strasbourg Court has posed to the parties in K, which we find in E8 of Mr. Luber's bundle. That's what he's referring to, as I understand it.
It's also, it's there, and it's set out also on page 13 of Mr. Luber's printed case.
I thought it was set out.
Well,
It's E8.
E8,
Did the applicants have the opportunity to have the proportionality?
yes, there's a have missing, yes.
Determined? No, they didn't.
You say no, they didn't, but so what? It's nothing to do with you.
No, I don't say that. What I say is we're not deciding that here.
But you would in this case, if you were asked that question, say it's not a case that needs to be considered because it's excluded by the legislation in this case.
Yes. So this is where I was going to go to.
But not in the K case.
But this
Not
is just
let's say K.
I'm sorry, this is just because we have to take it on faith that the statutory scheme matches proportionality, simply because it's the scheme enacted, or do we...
Well, unless there's a direct challenge to its compatibility, not on procedural grounds, but on substantive grounds.
Procedural grounds, but on substantive.
Or, for example, on discrimination grounds.
I mean, then you take a case like Lord Brown posed, and you say, how can it be so that it's going to be axiomatically compatible in every single, or have axiomatically compatible effects in every single case?
Well, my Lord, in the same way that was said in K, and the same way it was said in a lot of earlier cases.
Yes,
Are you saying...
The same way, respectfully, as it was said in Pinnock.
You're saying in this particular... What you're saying, as I understand it, is the way Strasbourg has put it means that the Article 8.2 exercise doesn't have to be conducted in every case. And there are certain types of case where it doesn't. And we should decide that the introductory tenancy system, because it's merely introductory, it doesn't apply. And in the demoted tenancy, it doesn't apply, presumably in part because they had their Article 8 rights carefully considered when it was decided to demote.
And it was modelled on the
introductory. And we should decide, as a matter of principle, that those are outside Article 8.2 review, as it were.
We should say that Parliament has acted legitimately, compatibly, in reaching that decision to have those schemes. That the cases have not clearly and consistently shown that is not open to a legislature.
But don't we have to do, even if we accept that, we would still have to form our judgment, wouldn't we? Rather than saying it may or may not be, wouldn't we?
Well, you would have to view, yes, if a challenge was made, the Parliament could not have done that. Then sure, I mean, there is legislation which has been held to be incompatible.
Yes, I mean, we can't, what I'm saying is we can't just say because if we accept your argument that Strasbourg says there are certain categories of, maybe certain categories of case where Article 8.2 doesn't have to be considered in each case, we therefore say this could be such a case and we have to decide it is. We then have to decide whether it is or it isn't.
Well, yes, but the only challenge that's been made has been on the basis of the procedural incompatibility. If somebody wants to make a challenge on the basis of substantive incompatibility, so be it. That it is not justified, that it cannot be justified, so be it. But it hasn't been made.
I see.
And it follows, does it, from your argument that it's virtually impossible to ever mount a public law challenge either, because this is a parliamentary scheme which must be taken to be proportionate, or have always to have proportionate results, and
I don't think that that's does follow from my argument with respect, my Lord. We set out quite a lot of domestic law, public law, because we take the view, and have long taken the view, in many circumstances have taken the same view, that actually domestic public law is much fuller than it's commonly recognised to be, particularly in the local government context. I say that because most of the textbooks on domestic public law are very interested, understandably, in national governmental relations. But when you come to the application of domestic public law to local authority decisions where people are engaged with service provision and so on and so forth, the law has really been quite consistent for a long time about the need to take into account personal circumstances, the need for rational decision, the need for accurate facts, increasingly moving towards the need for reasons, to the point where it's almost the exception that they aren't there. And so we don't say, Lord Brown's example is a paradigm. The fact, though, that somebody is, my Lord, I use that example of the dying tenant who's going to die, very shortly, doesn't actually follow that it is irrational to evict in every case. I mean, in an introductory tenancy case, it might be the case. But take the cases that learned friend Mr. Drabble said would never, as I understood it, or almost never raise a proportionality issue, which is occupation pending redevelopment. Those cases, which in fact are the paradigm cases where you would actually block all development because you have a large number of individuals all raising their personal circumstances. But let's say we get the case of somebody where we want to redevelop, and X has lived there for 80 years and is now dying and will die in 6 months' time, may nonetheless still be rational and indeed still be proportionate to evict.
I entirely understand that. It's just a question as to whether there oughtn't to be a court looking at the question.
Well, we have no problem with judicial review. We haven't had it. We've had it for a long time. We'd be rather in great difficulty trying to argue.
Are you happy with judicial review of the proportionality?
We are happy. Yeah. We've said this.
You're happy with the judicial review of proportionality?
Yes, we are.
But that's on the basis that it might be regarded as not proportionate by the court, but the court might think it was within the range of decisions to be so thought by the local authority.
It's a fairly standard approach. It's only the difference between, the same difference is between the position before the convention where a non-secure tenant could raise a Winder defence, if you like. And Winder wasn't the first tenant raising that sort of defence. There have been cases, I think your Lordship will remember, in the Court of Appeal, before Housing Act security overtook it, in which Winder-type defences were raised and were upheld in principle. Now, we recognise, of course, we do have to have regard to the convention. We're not trying to shy away from that, and I'll come to that when I come to section 62. B, we're not suggesting that section 21 can be exercised without regard to the convention. We do accept that, but at the end of the day, I don't want to get into the section 62B, but at the end of the day, it is our decision. And we are saying, and that's the only submission we're making at this point, that in these schemes where Parliament has clearly considered, and this is getting very close to the section 62B point, that in these cases where the Parliament has considered, carefully considered, and justifiably reached a decision not to allow a proportionality hearing in certain tightly defined cases where Parliament has defined that, Strasbourg has not ruled that out. The point I was trying to make is that we are not addressing here, we are not concerned with, for example, joint tenants' notices to quit, or arguably a K situation. We are looking at those cases within two schemes, in effect, demoted and introductory, where Parliament has said, without there being a proportionality, an independent proportionality determination, the court shall make an order.
What if a demoted tenancy was determined by one party serving notice to quit?
The notice to quit approach I was actually coming on to. It is not necessarily the case that the only solution to that is to provide for a proportionality hearing in every case. I need to say something about this. This is directly to Lord Newberger in his other role, because this may end up before you very shortly, because I have just argued this in the High Court unsuccessfully and then seeking leave. So I don't want to be thought that I'm trying to get gains for another case. But if I didn't say that now, my Lord might think I was being a bit sneaky when I turn up seeking permission in a week or two's time, asking for permission to appeal. But there is a very strong argument, we would say, and we would say this is not ruled out by 110, that there are areas of the common law which do require to be developed, areas where Parliament has not clearly adopted or considered, where it cannot be said, I understand the general principle, we have adopted the common law, the statutes have adopted the common law, therefore section 62 applies regardless. But that again was a general approach. It didn't amount to an endorsement in our submission of every common law rule. There was never that sort of argument. And it's our contention that what Lord Hope and the majority were focusing on in 110 is the correct general approach, the approach in principle to the 1998 Act, but the framework is dictated by alternatives, read down under section 3, read down or give effect to under section 3, or declaration of incompatibility under section 4, pending the final outcomes, which section 6 protects use of the provision in question, just as do sections 3.2b and 4.6, and as confirmed by the absence of adoption of Article 13, effective remedy. But we've not understood that to purport to address every detail of the common law. And it remains, and may remain the case, and I think this fits actually with what Lord Walker says in Doherty, at 104, paramount consideration will be whether the composite legal scheme in general, and the offending provision in particular, clearly represents the considered intention of Parliament. So what we're saying is we are only concerned with those cases. So we're saying that it is possible that there are detailed areas, aspects of the law, should not wholly govern to the nth degree by 110, meaning that those cases where it might be said a particular common law rule has not been considered by Parliament, nor can it be taken to have had it in mind. And that may, if I construe it in light of the Convention, call for reconsideration. So, I mean, our answer on joint tenants' notice to quit is that the rule needs to be reconsidered in any event.
Like the gypsy provision in Connaught?
The gypsy provision in Connaught was held to be incompatible.
Yeah.
But it was more direct there.
I see.
There was just protection and not.
Well, it's quite a good example, though, isn't it, of the general approach. I mean, in Connaught, there's a long passage giving you the point that you've been addressing us on most of this afternoon, which is the margin of appreciation, particularly in economic policies and housing and so on and so forth. And yet you get to the critical point in paragraph 83 there, which is, let's see what the procedural safeguards really are. And of course, in the case of the gypsies, they were effectively absent. But they do seem to take the view that you've always got to have regard to that if you're looking at the provisions in the context of Article 8. And you've accepted that Article 8.1 is in play, and I find it difficult to see why one isn't examining at least the question whether the scope of the margin of appreciation has intruded, even allowing for that margin. Nevertheless, you've intruded into the personal sphere to the extent that you need to examine the proportionality issue.
I accept that it is always relevant whether there are procedural safeguards. I'm saying that Strasbourg allows that there may be schemes which don't require it. That is my sole point.
Can I just ask, if the essential difference between you and Mr. Drabble and Mr. Luber boils down to this, that you would accept judicial review on a European Human Rights Convention basis, but it's got to recognise that the primary decision maker is the public authority, and therefore it's got to adopt a sort of broad aspect. Is that really possible? That's a sort of traditional common law judicial review thinking, but is it really possible in the convention context? Once you come to a conventional issue of proportionality, whoever you're talking about, don't you actually make up your mind and identify a single thing as proportionate rather than say, well, there are a whole range of things which might be proportionate, and if you fall within some bracket, it's all right and we won't interfere?
Proportionate is relative. It's a relative concept.
Proportion is a balance, but I mean, is it really... is this distinction really an existing one, a real distinction? I think Mr. Drabble says that to save the legislation, it may be a problem about his submission, you've actually got to review the public authority's decision as if you were taking it yourself.
Yes.
You say, no, you've got to review it on the basis that the public authority is taking the decision, and all you're doing is giving it a general glance, or perhaps quite a closer glance, but you allow them a very considerable margin of appreciation, to use the phrase.
Allow them a margin of appreciation.
Yes. But I wondered if the distinction is really real in this context.
Well, it's the same distinction that the courts have applied for years. There can be more than one proportionate response. There can be more than one reasonable response.
Once you know all the facts, wouldn't a court be bound to make up its mind? Was this or was it not proportionate? When it was reviewing a local authority decision? Yes or no?
Your Lordship is implying, I think I was sort of judicial realism, and implying that is applicable in judicial review. It may be that there would be very, very few cases where there was a difference. But it is important to the authorities.
Well, I think it might make quite a lot of difference if all you were saying was, let us see whether they acted. I think one would end up resorting to the words reasonable. Did they act within a reasonable margin? But that's not normally the proportionate test.
No, I appreciate that. Look, there's a question of expertise and competence in decision making.
I mean, there's Lord
Everyone is. I'm so sorry, Lord.
I'm sorry. I mean, there's Lord Bingham made plain in Huang. I mean, of course, whoever is deciding proportionality, even if the court is, it's giving due regard and weight to the pre-existing decision of an authority, which, of course, has its own expertise, its own wider range of an appreciation of how this particular case slots into, the overall scheme and all the rest of it.
Lord Bingham said explicitly that it is not a review jurisdiction. It is a jurisdiction to take it.
True, but giving weight to the authority's view before.
That's where it starts. But the reason, the point I was seeking to make to my Lord Mount,
I'm sorry, I interrupted,
was there are decisions about such matters as antisocial behaviour and the interaction of them of antisocial behaviour with both the demographics and the economics of an area. And Mr. Stillitz, in the evidence he was quoting, started off talking a little bit about this, that an authority may wish actively, and we put this in our case, we'll come to it later, but where an authority may well have a policy which it is pursuing of, the easiest way to say is zero tolerance, in order to build up an area so that I'm told, I'm fearful to say this, my lady may correct me, that Longsight was once considered a rather attractive area, rather than centre. But perhaps
I'm not going to give evidence, Mr. Martin.
However, but the point is that there are a lot of policy elements in antisocial behaviour issues, and there are a lot of quite fine policy issues. It is not a relatively simple or crude balancing. This person has done this person is to be evicted, yes, no, which essentially is what is considered in the reasonableness jurisdiction. The moment we have to prove all of those elements, we are producing to the court senior officer evidence of quite complex matters that need to be considered and digested by the authority, often in a very fluid way that they're developing all the time. Many of them not really capable of reduction to clinical propositions of evidence. Nor is it true to say, and it's certainly not true to say, that the whole policy is embodied in, well, look, we'll keep them out of the area. That sort of decision can be protected and enhanced on a secondary review in a way it simply cannot if we are putting all the material to a judge in order to weigh it up, nor leave aside the massive, and I'm not exaggerating on a cumulative basis, the massive cost of doing that on a routine basis.
But isn't that just what you had to do to get your demotion order?
We had to do it, yes, no. To a certain extent, yes. We did that to get the demotion order in order to recover control without it being susceptible to a judicial decision. In other words, it's only part of the way. After that, we are allowed to take a wide range of considerations into account for ourselves and deal with it. In the main...
Entitled and bound. And you're conceding that you have to take the proportionality decision at the second stage.
Yes.
But you say this Parliament has said, well, you alone can do it. That falls within the margin of appreciation. And what I didn't understand, you said there's been no challenge to the substantive compatibility. It's all procedural. I have great difficulty in divorcing the procedural from the substantive in this situation. You're saying, really, it seems to me, it's of the essence of this scheme that Parliament's saying it's up to us and not up to the court.
Yes.
But it seems to me that is precisely what is challenged here.
Well, yes, indeed, that is challenged, but it's challenged on the basis that the Strasbourg requires that there be that procedural safeguard in every case. I'm only using procedural as a shorthand for that proposition. I mean, I can see, Your Lordship, there's an overlap. I'm not saying that it's a procedural challenge that has no merit. To the contrary, I am saying that there is a difference. I accept that. But that difference may be a matter of substance, but I'm not talking about the substance of the proportionality decision in any given case, is when I use that expression. or substance of the or the weight of the justification for having such a scheme. What I was saying was there'd been no challenge to that.
How long did the original proceedings before the recorder take?
10 days.
10 days. And they produced a 100-page judgment?
Yeah. And then we had 2 more days on the JR, His Honour Judge Holman's judicial review of the decision to evict. Lord and the lady, partly for reasons of time, not because I've already used a lot of mine, but also because, as I did say early on, either your lordships, your ladyship do see some force in what I'm saying, or you don't. And after that, I'm really repeating myself on that first point. I really do propose to move on. What I wanted to say, though, to emphasise here was that we should not be allowing the sorts of cases that are decided within parameters, we are looking at, and our propositions do go to cases where Parliament has adopted a scheme that does avoid an independent determination, but does provide for the involvement of the occupier. There may be other cases which don't fall within what I'm saying here today, which do fall, which Strasbourg would say. And all of those in our submission are much closer to the sort of cases that we've derived from Strasbourg.
Could you? Are we still on the first of your headings?
Yes.
We are we?
Yes, that's why I was trying to move along.
Right.
And I was coming to the second part of it, which was the Grand Chamber.
I see. I was just going to say, I didn't think we'd heard anything about the Grand Chamber yet, so we're about to, are we?
Yeah, no, absolutely. I'm sorry, I said, coming to the end of my first point, it wasn't my first head. No. Lord, it is, we submit, self-evidently Grand Chamber decisions which have the greatest force, and only Grand Chamber decisions which fall within Lord Rogers' dictum in AF, which I shall not mispronounce in Latin, as I would if I were to say it. Strasbourg has spoken, the case is closed. Also, I don't know if your ladyship just want me to give you the references for reasons of time, rather than going to, because they are very short passages, and to go to them is probably disproportionate. Sorry. And Lord Carswell at 108 does refer, whatever latitude section 2.1 gives us, the authority of a considered statement of the Grand Chamber is such that our courts have no option. I'm in agreement with your lordships, we're obliged to accept and apply Grand Chamber principles. Lord Bingham in Anderson, that was Lord Carswell in AF at 108, bundle 10, tab 87. That was Lord Rogers' dictum was at 98. Lord Bingham in Anderson at bundle 8, tab 70 at 18, argued for the Home Secretary of the House should not follow the judgment. While the duty of the House under section 2.1 is to take into account any judgment, those judgments are not strictly binding. The House will not without good reason depart from the principles laid down in a carefully considered judgment of the court sitting as a Grand Chamber. And for that is how he cites Altenbury. And I think there's been reference to Lord Brown's speech in Horncastle, but he was clearly talking likewise about Grand Chamber. Not saying, Lord, he was saying that it wasn't true, but that was what you were talking about there, was Grand Chamber.
We haven't asked for a Grand Chamber in K.
Lord, they wouldn't do so till after a decision of this section. No? Is that right? Well, they haven't. They haven't. Sorry? I'm talking to you, I'm talking to Tom. Anyway, they haven't. You can ask them to. You can still go. Well, you can't go now, because you haven't got a decision. But if the government chooses not to go to the Grand Chamber, and it is in effect a choice, because Article 43 is clearly engaged, as to say, a request for referral must be accepted if the case raises a serious question affecting interpretation or application of the Convention or the protocols or a serious issue of general importance. And of course, if something goes to the Grand Chamber, it is much more likely that other jurisdictions will seek to be involved in it. In our submission, it's far from clear the Grand Chamber would uphold the proposition at its most general. If we are correct on Zahentner that it applies also to the private sector, because it will cut through virtually all signatory states' housing law. And Mr. Luber said, no, never mind, I think you'd make a different point. But as far as we've been able to establish, and we have tried to do some comparative research responding to Lord Mance's inquiry, and we've looked at 35 signatory states. Every country has exceptions from security.
Has what?
Exceptions from security, by which I mean mandatory grounds or by which I mean no independent proportionality review. As far as we can tell, everyone has. None has as unlimited a fallback jurisdiction analogous to that which Messrs. Drabble and Luber contend for, applicable wherever there is no statutory security. None has a general blanket. And only some, many, I think most, have a fallback jurisdiction or of the long stop nature that Mr. Stillitz refers to. But in every case, it's statutory and defined. In our submission, such an important change with such considerable economic implications, this is if private sector is engaged, must go to the Grand Chamber. And indeed, part of the purpose of the Grand Chamber when it was created by Protocol 11 was for it to handle the larger issues which address legal inconsistencies, which touch on national political sensitivities. If the government is unwilling to go to the Grand Chamber and test the position, then if this court takes a different view, it can hardly really say, no, you must follow a section. If this court says we don't think that this is right, and the government says, well, we're not going to the Grand Chamber, then in our submission, the argument that you must follow Europe is that much weaker. On this point, likewise, I don't think I can take it any further. This is what I've tried to do into my headings, is to break them down to relatively small, short points. Either this is seen to be a new development with significant economic, social consequences, in which case, in our submission, prima facie, the argument is sound that nothing below Grand Chamber should force us to what we say will be a wholly new body of housing law, or it is not. Either it's viewed that way or it's not. There's no real middle position that it's a new development with such significant consequences, but we'll move now without going to the Grand Chamber in our submission. Seems to us somewhat contradictory. Obviously, that does import the proposition that it's a major change in our domestic housing law, but that is obviously something I'm coming on to. But I would describe the distinction between those with and those without food security as absolutely central to domestic housing law. I move on to the second heading, then what the jurisdiction is and how exceptionally it will arise. And obviously my submissions here, and I suspect the rest of my submissions, now simply accept that the Strasbourg cases say are what they've been contended to say, that there does have to be in every case.
So 2 onwards is assuming you're wrong on 1.
It's assuming I'm wrong on 1-1. It's not, 1-2 was go to the Grand Chamber. I'm now going to address these 2 issues, what the jurisdiction is, that is to say the difference between Mr. Drabble and Mr. Stillitz, and how exceptionally it may be thought that it will be invoked. The latter is relevant to the issue of referral to Grand Chamber in our submission, and to the issue, which of course is in many ways our main fallback, which is declaration. But there should be a declaration of incompatibility if we are wrong on 1-1. Lord Lady, given Mr. Stilitz's movement during his submissions on the nature of the jurisdiction, and while we sympathised with the ingenious way to reconcile his 2 interests to avoid adverse findings at Strasbourg and not to damage the domestic system, we simply do not think that we can subscribe to it. We find nothing in McCann to support it. It was not based on the hardship to the individual. It was about procedural incompatibility, for want of a merits review, or my assumption that I now work forward from. Porlich was a case in which there had been an adjournment because of sickness. Paragraph 44, that didn't affect whether there was found to be a breach. And frankly, in Zahentner and Blekic, all we find is propositions to the contrary. We don't see how you cannot weigh up the reasons. In our footnote on, as it were, our dying tenant, as opposed to Mr. Stilitz's dying tenant, in I think it's footnote 181 of our. No, it wasn't 181. I'm sorry, that's wrong. In our printed case, we give the example of saying, well, we have to evict this person because if we don't start by April the 1st, we'll incur £10 million penalties, or we will lose £100 million of European grant, maybe, if it's not done by a certain time. So we don't see how it is possible to go into hardship without going into reasons, the authorities' reasons, nor do we see that this is a jurisdiction which has any support in the case law. We're also concerned that if tempted into a modest adjustment in terms of Mr. Stilitz's approach, it won't stand up. But then we've taken the step, and so it's a step-by-step approach to breaking down what we say is the domestic legal structure. we would say it wouldn't make much difference, because quite clearly such considerations will come up on a proportionality hearing. Lord Brown has just, as it were, put exactly that to me. And on our submission, on either approach, whatever interpretation of the jurisdiction you find in favour of, there's absolutely no question at all of it being rare or exceptional for it to be invoked. And Lord, in Doherty, again, I'm really just making a quick reference. Obviously, if your Lordship's relationship want me to go to, I will, but for reasons of time, these quick references, I'll just give the reference.
What would help me, Mr. Arden, is if actually, besides this very useful headings of your submissions, you could put alongside them which paragraphs of your lengthy printed case, which I think goes to over 80 pages, where we'll find the arguments there in relation to
we'll try and do that overnight.
Thank you very much indeed.
We will do it overnight. That's a royal week.
Was that loyal or what? Or royal?
Royal week. I was going to refer, in any event, Lord Hope at 20, making the point that every solicitor would need to consider the jurisdiction, raising the human rights jurisdiction. That is absolutely right. They will have to consider it, and however high the bar is set, however exceptional it might be predicted, and we agree exceptionality isn't a test in itself, it might be predicted that the jurisdiction will be, in the overwhelming majority of cases, it will be impossible for a solicitor to say there is no chance at all that a single county court judge might find that there is sufficient material to justify a hearing and or to rule that it would be, say, in breach of the convention to evict for the next 6 months, again using the dying tenant. That's to say, it would be impossible for the solicitor to say that with certainty. It's the first stage. And it goes to the nature of our adversarial system. It goes to the fact that any and every tenant can claim that eviction will be seriously damaging to himself or his family, whether physically or mentally, or at least that it will cause great distress, because by and large eviction does cause great distress and damage. It goes to the fact that most county court judges do wish to avoid evicting if they possibly can. It goes to the fact that when acting for a tenant, we are under, as counsel, or solicitors as well, a positive professional obligation to advance every point the client wishes to be advanced.
But I'm sorry, Mr. Arden, to interrupt, but I mean, the starting point for the solicitor's, so to speak, consideration of this is he's already told himself the one thing that's clear is there isn't an arguable case here of irrationality, of Wednesbury unreasonableness, of a public law challenge. On the face of it, this is a reasonable decision, because otherwise he'll be taking these defences anyway, won't he?
Lord, experience shows, and with the body of case law we have, that that does not happen. They do not take a perversity challenge in every or many cases. There may be more now than there were. There may be more now since Kay than there were. But they are asking the Lord, it's one thing to say, I do not think we can challenge the decision of the authority first, because by and large the solicitor does not take the same view. I think this Lord Mounts what I call the judicial realism, that it's worth a shot at a judge intervening and using his own criteria. But here you have the judge's own criteria are going to be called into paid in aid. And if there is any chance of doing so, then we are going to have to do so. Also goes to the fact that even acquiring an adjournment, if we don't want to be evicted, is a gain. Putting off eviction for a few weeks or months The bar, however high it is set, is immediately taken down a notch or 5 to the arguable. And this isn't illusory, this is the daily bread of the county court, where cases are adjourned for weeks and months at a time. A skillful lawyer can get it into years.
Well, what about Mr. Luber's point, speaking no doubt from experience, that county courts get through
Those are
cases involving a test of what is reasonable, 10 an hour?
Lord, not if they're represented. When did anything with a lawyer take 5 minutes? Lord, I'm sorry, if people are going, if the tenant is going to say, I am suffering from, all the tenant needs a social worker or a psychiatrist or a doctor to say this is going to cause great distress, then the authority is axiomatically going to need its own to resist. And that is precisely what is going to happen. Or at least it will cause a delay. Solicitors' counsel acting for tenants simply cannot be asked to take on themselves the burden of saying no way, no chance, no how. It creates a very, very low threshold. And one is addressing this in a context in which there is a wide variety of judicial reactions and subjective attitudes. We all know this, it depends on who you draw on the day. I'm sorry to be that blunt, but it does. And every county court practitioner, I mean, the law looks at Mr. Luber and say, well, Mr. Luber doubtless knows this in test. I also act for tenants. And indeed, I'm in the chambers where a very substantial body of work is for tenants. And I know the tests that are being applied, and I know the question that's being asked, and I know what one says when they say, well, is it possible I could get a judge to see it that way? And the answer is almost invariably yes.
And is that enough to get legal aid?
Well, I was coming to, in fact, it was my next line. I accept that there may be a measure of self-restraint imposed by public funding requirements, but the legal aid test borderline is what you need, is 50-50. It's still extremely subjective. And secondly, they weigh into the account the fact that cases involving loss of accommodation are of great importance to the client, so even where the merits are less strong, there's an additional reason for funding.
It might be said that this tends to support Mr. Silitz's suggestion as against Mr. Luber, that we should, if we are against you and go along this line, we should give some fairly strong indications to the profession as well as to circuit judges as to how they should approach the matter by saying, if we think it's right, that it would require not an exceptional case, but the sort of facts it would require.
Well, I accept that, and it is one of my submissions, number 6, identifying exceptional circumstances. If I can just finish off my...
I'm sorry.
I'm sorry, my response to Lord Roger. The moment the court says, yes, there is something to be tried, then legal aid is axiomatic. So the only risk is of taking it that far, which is, if I may say so entirely properly, I don't want anyone to think I'm criticising tenants' lawyers. If I do, my Lord Newberger is going to remember 1970s in Bloomsbury and Marylebone and say that's what I used to do. Probably not as well as Mr. Luber, but I do once recall getting a squatter's case to 1 year, and the other side still had to ask for an adjournment, and it was a summary case. The judge was not congratulating me.
Could I ask you, I mean, you just to continue this point, we were shown 55.8, Rule 55.8 in the hearing, and the circumstances in which you can get a case allocated to a track. Are you saying that if you get to the stage of persuading the court to allocate the particular dispute to a track, in other words, for consideration?
Not to dismiss it.
Yes, that's right, not to dismiss it, but to look at it and put it on a track where it will actually be examined, so you can look at the importance to the defendant and all that kind of thing. Legal aid will follow axiomatically.
Exactly, yes. Yes. If you persuade... That's right. I'm going to ask, is still a little... Very likely.
Very likely.
But I don't think one can always say, because you've got different legal aid officers and they
Yes,
take
yes.
different views.
Yes.
And frankly,
Yeah.
it depends on public funding at the time. What I was trying to say, and I think Lord Neuberger actually touched on this at the time, it may be done pro bono to that point, but you also have duty solicitor schemes. And sometimes you have our pro bono unit, of course, it's good that we do. Pupils getting experience, and firms, local solicitors may find that it works out in their favour to do that bit pro bono. And of course, we're concerned here, and it is right to say this, we're concerned here not only with introductory and demoted tenancies, we are also concerned with assured short-hold tenancies. Because what were called registered social landlords and are now called private registered providers of social housing associations, registered housing associations to me anyway, have all been held to be in practice within the Act on evictions. So we are talking actually about something that is going to affect 17.5% of the national stock, national housing stock, not of the rented stock. I mean, that's the whole social housing stock, I'm not saying. But of that 17.5%, 8.5% are housing association, and many of them will be ASTs. I'm not of course saying that 17.5% will all suddenly come within it. If a tenant, when Mr. Luber says it will take 5 minutes, not even Mr. Stillett's narrow jurisdiction falls within it. If a tenant finds a doctor, social worker, the authority finds they're unprofessional, the judge has to choose between them. To avoid this, you have to be in a position to say the argument is unsustainable, but at risk of repetition, it will not. When is it not the case that eviction will have seriously damaging consequences? And all of this pushes up the cost to the landlord very significantly and wholly irrecoverable. The public funding rules don't allow us to recover at that stage.
And even if they did, your prospects of recovering in practice would be very slender.
Yes, I mean, they don't, but yes, you wouldn't get it back.
Well, if they were in person, you wouldn't get it back.
You wouldn't get it back in person, and you wouldn't get it back if they got enough money for a lawyer, temporarily. I mean, the reality is that chasing the cost would be very, might even be disproportionate itself. If financial considerations come into play, e.g. regeneration of the inner city, and you've got redevelopment and you're trying to clear an area, and so you've got people who've been using it as short life accommodation, which you need to clear by a particular date. It requires senior financial evidence, and allocation of pressure on stock will have to be proved and reproved. In our submission, 5 minutes is just not at all realistic, unless we're talking about the unrepresented, in which case we're now talking about taking advantage of the least resource, who puts up nothing, the least well resourced. Of course, when somebody is unrepresented, a judge does tend to lean towards not acting for them, but to looking for points, and as they should, as a judge should. So you have a judge doubtless and rightly anxious to discharge his new jurisdiction. Nothing that he can see might suggest further investigation.
Can I just ask you, Mr. Arden, you gave us a figure a moment ago, but the total housing stock or the total housing association stock is not really relevant, is it? It's the number of individual cases which raise this sort of problem.
Well, I'm not sure, respectfully, my lord, that it's the number of individual cases, it's the proportion, it's the percentage of the class affected. I mean, Parliament passed a law which was going to be potentially moderated, but was only aimed at 10 people, and 9 of them would be in a different position because of the moderation, and it might be a small number, but it would be most of the quantity within Parliament's framework. but we don't have the figures that your lordship would I'm sure like.
Mr. Arden, it's past 4 o'clock. Shall we adjourn until tomorrow?